Hello, everyone, and welcome to STENO 24/7, a court reporting dictation channel for court reporters. And shorthand and stenograph and whoever needs these videos, you can surely have them. They are for everyone, but I do make them specifically for court reporters. Oh my gosh. Now, with all that being said, today I want to read to you the state of Wisconsin versus Stephen Avery. This is going to be video number 22. So if you have not listened to the other Stephen Avery videos, please take the time to go over to that playlist and on my channel, and you can listen to all the other videos that I have done on this case. And I am trying to read the whole case. So if you listen to them back to back to back, you should get a gist of what's going on. Now, if you've been with me and following me, we are now, Mr. Kratz is finally wrapping up. Yes, he is. Mr. Kratz has taken up from video number 1 up to video 22. So that lets you know he's doing his opening statement. And so he's trying to convince this jury, you know, and get him on his side because he wants you to return a verdict of guilty. That's what he said before we left on when we left on the last video. So we're going let's just do this. Let's go ahead and start with who is talking next. Now, Attorney Kratz has just said thank you, Judge, and has rested his opening statement. So now we are with the court. Ready? The court. Thank you, Mr. Kratz. Members of the jury. It's 11:45. It's a little earlier than we normally take our lunch break, but I don't believe there is enough time to get started with anything else before lunch. During the course of the trial, the court will attempt to give you a break every hour and a half or so, because I realize that your attention is required, and sitting for much longer than that can impair your attention. I do want to remind you at this time, as I will periodically throughout the trial, that you are not to begin your deliberations and discussion of the case until all of the evidence is presented and I instruct you on law at the conclusion of the case. Do not discuss the case among yourselves, including the opening statement given today, or with anyone else until you begin your final deliberations in the jury room. We'll take our lunch break now and resume at 1 o'clock. Jury not present. The court. You may be seated. Counsel, in terms of the schedule for this afternoon, is the state going to have some evidence to present after the opening statements? Kratz. We will, Judge. We'll have as many witnesses as the court wants to proceed with this afternoon. The court. All right. We'll see you back at 1. Attorney Strong. I have just one quick. The court. Go ahead, Attorney Strong. Matter, if I might. I decided against interrupting Mr. Kratz's opening statement because I thought this could wait. Honestly. And I don't like to interrupt someone's opening. But probably in the first 20 minutes of his opening, Mr. Kratz explained to the jurors that the presumption of innocence persists only until that moment when the evidence overcomes it and proves guilt beyond a reasonable doubt. I understand the argument. I understand what was meant. No ill intent was meant. But that's enough of a variation from the actual instruction that the presumption of innocence attends the defendant until after closing arguments and deliberations begin, that I simply would ask the court to repeat part of that presumption of innocence instruction this afternoon before I start. We don't have to make a big deal out of it. I just thought an abbreviated reminder might help. I also noted in the state's PowerPoint slide that explained the element of false imprisonment that the language during her lifetime was omitted. That's, I think, the kind of thing that the court already has covered and can cover again. But it might be a good idea, and this covers me too, for the court simply to remind the jury that all legal instructions come from the court in the end. The court. All right, I did. I do recall the statement regarding the presumption of innocence that you referred to, and I do agree that the precise extemporaneous statement for Mr. Kratz is not technically correct. I'm going to grant your request and repeat the presumption of innocence instruction before you give your opening. And we are ending on page 108, verse 24. Hopefully that helped you a lot. That was something different, you got the court in there, you got different attorneys, and that's good practice for you. So thank you all for coming, and give me a thumbs up if you like this, and I'll see you at the next video. Happy writing, everyone.